Hi everybody and good morning. Okay, it looks as if we've got most of the people that are joining into the Zoom room, so let's get underway. So as I said, very good morning to you all. Thank you for joining us this morning for this K3 Hub structured CPD session. For those who haven't already met me, my name's Marie Wadeson and I'm a managing director here at Quantuma, and on behalf of our parent company, the K3 Capital Group Limited, and not PLC these days, I am responsible for the K3 Hub, a member network for professional advisors developed by us and other companies within the K3 Capital Group. Since we launched in the spring of 2021, 2,400 like-minded professionals from across the country joined our network, through which they can access a range of CPD and training sessions, not dissimilar to today's event, and referral fees for certain types of work referred into the group. Today we've got a 3-hour CPD session on employment law and HR, delivered by one of our most popular speakers at the K3 Hub, Toni Trevett. Before I introduce you to Toni, we do have a few pieces of housekeeping for you. So as you probably will have heard as you entered the Zoom room, we are recording today's session. If you need to refer back to it at any point, it will be on the K3 Hub website next week. Q&A function is open, so please do feel free to ask questions as we go along. Just a request from our speaker today, if you wouldn't mind using the Q&A function to ask your questions rather than the chat, it just helps us stay on top of those. We are going to post the slide presentation into the chat for you at the beginning of the session, and you can download it from there. I expect the team running the session behind the scenes will post a couple more times for those who may join a bit later on. We have got a couple of short breaks planned. I think we're probably likely on the hour, just to give you a quick comfort break. Anyway, on to today's session in that case. So I'm very pleased to be able to welcome back Toni. You may recall that Toni ran a couple of our employment law and HR sessions last year. Toni's a qualified HR practitioner, mediator, trainer and coach. She's had an in-depth understanding, or she has even an in-depth understanding of grievances, disciplinary hearings and appeals. She hears cases for the Employment Tribunal Judiciary. I need to put my teeth in this morning. And she worked for large and small companies in HR and employee relations roles. Finally, just one point here, Toni, I understand, has been experiencing some Wi-Fi issues this morning. So if she does disappear, please just bear with us while we get her back. There is a team in the background running this, and they will just make a short announcement in the instance that happens. Okay, so today's session, Toni will broadly cover what's new in employment legislation over the next 12 months, a key case law that shapes how people and situations are managed legally, hot topics in HR, what legislation we might see in 2023 and thereafter, and then changes in statutory calculations. Very much hope that you enjoy and get value from today's session. Just wanted to flag a couple of other forthcoming events to you before we get underway. We have an in-person budget event with our regular guest speaker, Jeremy Mindell. This will be held in Maidenhead on the morning of the 16th. If you are in the area or happen to be in the area that morning and you'd like to join us, please do let the team in the background know via the chat, and we'll send you all the details. And finally, our next CPD event is on Friday, the 21st of April, and covers issues relating to entrepreneurs. There'll be more details and invitations to follow. Right, that's it from me then. Toni, over to you.
Lovely, thank you so much. What a lovely introduction. So welcome to your employment law update. Hopefully the worst that will happen is that I'll have to turn my video off rather than disappear entirely, but let's see how we go. So as Marie very kindly introduced me, I have a background in employment law. I've worked for lots of organisations, large and small, keeping them out of trouble and dealing with issues as they arise. And I sit for the South London Employment Tribunal Service part-time. And we are particularly swamped with cases at the moment. Hence, if any of you are involved in that, it's taking so long to go from submission to hearing date. And in fact, the Law Society press release recently highlighted the continuing trend in outstanding cases at the tribunal. I think it was in December 2020 that it showed 50,518 outstanding cases. So we're doing increasingly more and more cases online to try and get on top of that. But virtual cases come with a whole host of difficulties, from, you know, connection problems. If I hear your mute is on one more time, I think my brain might explode, to people reading, you know, 300-page bundles on a phone, as well as, you know, connecting to the hearing, Wi-Fi dropping in and out, noise in the background. It's really difficult for people. And then every so often there's a complete gem. And I've had some really funny experiences. I had, for example, one case where somebody was giving evidence, and behind them a door opened and their boyfriend appeared completely naked, towel drying his hair, which was slightly embarrassing for all. I've had someone give evidence when their doorbell rings and they literally get up and open the door and take a McDonald's delivery for their lunch. We've had levitating paperwork, was probably one of my favourites, where I could see the person giving evidence, but every so often their hand would reach out and take a piece of paper from the air. And when they were questioned, it turned out their mother was hiding under the table and helping this person with their evidence. I mean, it's slightly disappointing now if it all goes to plan, but we've certainly seen it all, I think, in trying to pick up on outstanding cases. So as Marie said, we're going to cover a few main things today. Case law from 2022. I've tried to pick out sort of broad interest cases from last year. I've avoided the ones that we talked about when we did the 2 sessions in 2022, so you won't have repetition. Next, we'll try and look at what's coming, so what the future will look like. And then finally, I thought we'd do a little bit of a myths busted session. So look at some of the common things that people often present as absolute fact, and it turns out that they're nothing more than a myth. We'll try and do a couple of breaks, and I'll aim for on the hour. Excuse me if I look across every so often, it's because my clock is over to my right. And as Marie said, if you have any questions, please sing out and put them in the Q&A, and I'll try and get to them after each break. So that's broadly how we're going to spend the next 3 hours. So we've got a few poll questions for you. And what we'll do is put each one up, ask you to answer it, and then where it's relevant in the webinar, we'll pick up on your answers. So this is the first one. Is calling someone a bald, something rude, harassment on the grounds of sex discrimination? So is the bald something that could be an act of sex discrimination? So I'll let you spend a minute or two answering yes, it would be, or no, it wouldn't be. Well, there's an even response to that one. So 52% there have said yes, and 48% no. Okay, lovely, thank you. Let's go on to the next one. All this interactivity. Question 2, is without prejudice the same as off the record? Again, single choice answer, yes it is, no it's not. Okay, so there we have yes, 26%, it's the same concept, and no, we've got 74%. Okay, thank you. Just 2 more. So third question, an employer can reject a candidate for a maternity leave cover role on the basis that the candidate is pregnant and wouldn't be able to work the full period. So could you reject someone who's pregnant because you're trying to cover maternity leave? So it's just a simple choice of true or false for that one. Oh, that's a very even split as well. So 48% of you think, yes, you could decide not to recruit someone, and 52% say, no, you couldn't. Okay, thank you. And last one. So an employee whose fixed term contract comes to an end cannot bring a claim for unfair dismissal. So if you're on a fixed term contract and it comes to an end on the date it's supposed to come to an end, that's not a dismissal and someone couldn't claim unfair dismissal. Is that true or false? So 78% say true, they can't claim unfair dismissal, and 22% say false. Okay, perfect. Thank you so much. Right, let's plough on, and when we get to the relevant sections, we'll go back to those questions. So, as I said, I'm just going to pick out a few key cases, and I've tried to keep broad interest. So I thought we should start with a COVID case. And this one is Burke and Turning Point. So in this case, Mr. Burke was employed as a caretaker and he started work in April 2001. He caught COVID in November 2020. And after his initial isolation period, sadly, his symptoms continued and he continued to suffer with really serious fatigue. He had very severe headaches, joint pain, insomnia, a whole range of symptoms. And because of those symptoms, he was unable to undertake even ordinary household tasks because he would tire really easily and need to rest and sleep and, recuperate a lot of the time. So he was also unable to do his job, and Mr. Burke went on sick leave from November 2020. Now, he had fit notes from his doctor, and the fit notes said that he had long COVID and described this as a post-viral fatigue syndrome. So after a period of time, the employer decided to seek occupational health reports in connection with him and his absence, and they did that in the April and June. And these reports contradicted what the fit note said. And the occupational health view was that he was fit and able to return to work and that he wasn't disabled. However, his symptoms didn't improve. In fact, some worsened, and he didn't return to work, even though he was told occupational health said he could. Eventually, after due process, the company dismissed him on the grounds of his ill health, and that dismissal took place in August 2021, so just shy of a year of absence. And he brought a claim for disability discrimination. So could long COVID amount to a disability? That was the question. And this is the first case where this has been decided. And the tribunal found that, yes, long COVID symptoms could be gives rise to someone having a disability under the Act. And they thought he was a credible witness. He hadn't exaggerated his symptoms. There was no financial benefit to him in remaining on long-term leave because he wasn't paid. And it was a physical impairment. It had a dramatic effect on his day-to-day activities. And because of that, and the fact that it was likely to last for at least 12 months, he did meet the criteria for a disability under the Act. So for me, the key takeaway with this one is that, these long COVID cases, post-viral cases, can definitely be deemed to be disability cases. So each case obviously needs to be considered on its own facts, and you need to take account of relevant medical evidence as well. And the other interesting point on this case is, of course, that there was a contradiction between what occupational health was saying and what the Mr. Burke's GP was saying on the fit note. And this is an interesting point where there's conflict. And I decided to look back at the guidance on the fit notes, which came out when the new fit note was released in March 2013. And that says it allows an employer to give precedence to the views of an occupational health practitioner over those of a GP. So the guidelines actually say that you could do that. And this means that employers may, in principle, be able to prefer or accept the opinion of an occupational health advisor over that of a general practitioner with regards to whether someone's fit to return to work. So the fit note is really an indication of someone's fitness for any work rather than specifically this work. So, and often a GP won't really have much information about what somebody does. So it's an interesting point, and the fit note is really an advice note. If it says, for example, someone is fit to return to work with certain adaptations, if an employer can't put in play those adaptations or doesn't think that that's appropriate, it's just advice, and they can ignore that advice and ask that person to remain on sick leave. You've obviously got to have good reason, though, if you're going to decide that the fit note isn't something you want to follow. So I would say it's definitely something you would do with a considerable amount of care and attention. And there's case law about this as well. And the things that you would definitely have to consider is that the OH practitioner should have appropriate qualifications and training in occupational medicine. That's the first point. Secondly, the case law says that the employee should be personally examined by the occupational health doctor or specialist nurse, and the decision that they give should not be made purely on a report or on the basis of a review of medical notes. And then thirdly, the written report by the occupational health specialist should be particularly specific and clear, and if possible, explain why that fit note should not be followed. And then lastly, if the employee is being treated or has been treated by a hospital, specialist or consultant, there should also be a current report that includes what that specialist has said as well. So there's a few things to be a little bit careful about in those circumstances. So long COVID can be a disability and have that protection. And if you're going to ignore a fit note and go with an occupational health advisor, you need to make sure those steps have been taken, because that's obviously a big decision. Okay, I next want to go to Smith and Pimlico plumbers, and I do webinars and employment law training year after year, and I've been talking about this one for many years. I mean, I think next to Nintendo's Mario Brothers, Mr. Smith must be one of the most famous plumbers, at least in employment law circles. He's been in the news now for so long, but he is at the end of his journey now. So this is all about Gary Smith, who worked for Pimlico plumbers between 2005 and 2011. And he went to court after a long-running dispute with the company about his holiday pay. And he was able to successfully establish that he had rights as a worker despite being engaged and treated as a self-employed plumber. So this is a status case, and an example where Pimlico plumbers got his status wrong, treated him as self-employed when in fact he was a worker and he was missing all the rights that workers get, one of which is paid annual leave. So he subsequently claimed that he was due accrued holiday pay stretching back to the full 6 years, even though he had taken time off and he had never raised this as an issue, but he was still entitled to it. So the question for the Supreme Court, because there's appeal after appeal on this case, is he entitled to the full backdated period of holiday pay? And this judgment is perhaps one of the most significant I've seen for a long time in relation to protecting workers' rights, because the judgment is, yes, he was entitled to all of that period. So a lot of annual leave that was due to be paid. So key takeaway on this point is we've really got to get status issues right with the people that we employ or work for us, because getting it wrong can be potentially quite expensive. So I think it's the decision really serves as a warning that if you've got self-employed contractors, have a proper look to see whether they're properly assessed. And the complication here often is you can be fairly assessed as self-employed for tax purposes and not for employment purposes. So the tests are slightly different. So if you've got any in your organisations, worth having a look. There's three main types of person that works works in employment, and they're the workers that we've just been talking about that undertake personal service. There are employees, and they're obviously the easy ones to spot. And there are what should be genuinely self-employed people in business on their own account at risk of profit and loss and those kind of things. So worth having a look to see, have we got the status right for all the people, worker, employee and self-employed. So Mr. Smith has ended his legal journey at long last. And I think just while thinking about holiday, there's probably another point that's worth mentioning, and this relates back to a couple of European Court of Justice cases, which were all about the use it or lose it concept. Written into many employment contracts is the fact that if you don't take it, by the end of the holiday year, you will lose it. Some contracts will say you can carry over 3 days or 5 days. Some don't. So you need to be clear what your own contract says. But these European Court of Justice cases were about the use it or lose it concept. And what the judgments say is that an employee will actually be able to carry over all their untaken statutory holiday entitlement from one holiday year to the next, unless the employer has and can prove that they have done several things. So the first thing an employer would have to do is to have taken active steps to specifically and transparently give its employees and workers the opportunity to take their holiday. So have we specifically and transparently given people the chance to take their holiday during the holiday year? Secondly, has the employer actively encouraged those workers and employees, formally encourage them if need be, to take their holiday? Now, we can't require people to take holiday unless it's something that you actually want to do. But have we actively encouraged them to do that? The only way you can require someone to take holiday is to give them twice the amount of notice to holiday you want them to take. So, for example, if someone is in a notice period and you want to ensure that they take a week's worth of the last week's worth of prorated holiday entitlement, you could write to them and give them 2 weeks' notice that they need to take that 1 week as holiday. So that's the only circumstances where you can require someone to take their holiday. So back to our list, have we, number one, taken steps to specifically and transparently give workers the opportunity to take holiday? Secondly, have we actively encouraged people, formally if need be, to take their holiday? And lastly, have we warned people in good time that they will lose it at the end of the holiday year if they don't take it? So I don't think many employers actually do this, and I don't think many employees or workers would know that this should be done. And I just think it's an important practice to keep your eye on how much holiday people have taken, how much they've got left, not least from which you might not want, half your workforce to have December off because they haven't taken their holiday through the year if you've got a calendar year. I think a simple, email, letter, just reminding people is all that needs to happen, or even, in regular one-to-ones, keeping an eye on how much holiday someone's taken. I think that would definitely suffice. So it doesn't have to be too big a deal, but certainly worth bearing in mind. Otherwise, there could be argument that someone should be able to carry their untaken leave over. Okay, another status type case is this one, Richards and Waterfield Homes Limited and Unity Build and Repairs Limited. So Mr. Richards worked as a self-employed carpenter this time between 2010 and 2018, and he was engaged under HMRC's construction industry scheme. Some of you may be familiar with the CIS scheme. And that's the scheme where a subcontractor can have 20% of their gross earnings deducted by the employer and paid directly to HMRC on account of income tax and national insurance. And at the end of the year, there's an adjustment reconciliation type process where there might be a balance payable by HMRC back to the worker. So use of the CIS scheme is inconsistent normally with someone being an employee. Hence, he was deemed a self-employed worker. So in 2018, he was told that contractors would in fact be going on the books, would be given employment contracts. And this contract stated that Mr. Richards will have been continuously employed from this date in 2018. He, however, thought that should be backdated to when he started work in 2010. So this was the issue. Am I an employee from the point you give me my contract in 2018 or from the point I started working for you back in 2010? So this went to the Employment Tribunal, and their decision was, no, you're not an employee at any earlier date. You commence your employment in 2018. He appealed because he didn't think that was the right review of the legislation, went to the Employment Appeal Tribunal, the EAT, and they overturned the decision and said, yes, you should have been an employee right from the word go. So to call you self-employed was, and this is what the judge said, manifestly false. And the judge at the EAT felt that the Employment Tribunal placed far too much emphasis on what the parties had agreed, and that their intention was for him to be self-employed. And the judge said, but this is just one factor, and you have to look at the whole, the holistic view, look at it in the realm of all the requirements for employed or self-employed status. So another good reminder that we've got to get these status issues done right, and that the intention of the parties, the documents that have been signed, they're only just one part of the assessment. You know, and really looking at the reality of the relationship is the only way to make those decisions. Okay, so back to our first poll question. And if you remember, we thought, or 52% of us thought, that being referred to as a bald something really bad would be harassment, and 48% thought it wouldn't. And this is the case of Finn and the British Bung Manufacturing Company Limited and Mr. J. King, so 2 respondents. There's never enough case law about banter and workplace language and behaviours, and this is another example. And yes, I did look them up, and they do make bungs, mostly for the brewing industry. I love it when a company says what they do on the tin. But Mr. Finn here worked as an electrician for this company, 24 years without putting a foot wrong, no disciplinary problems at all, until he was dismissed in May 2021. And what happened here was 2 arguments with the factory supervisor. They were 18 months apart, these 2 arguments, but they were both very similar in terms of language used. And in these arguments, on both occasions, Mr. King referred to Mr. Finn as a bald C word, which is pretty appalling. And on top of that, he also threatened to deck him and knock him out. So these are proper arguments. This kind of language is being shouted at him, but always referenced with the bald word. So to cut a very long story short, he decided to, on the second occasion, to walk out from work, and he didn't return. And his son just so happened to be a police officer for West Yorkshire Police. So he wrote a letter of complaint to the employer on police-headed notepaper, strangely, and Mr. Finn was actually dismissed for that. So the company said, you're trying to intimidate us, you know, using your son, hand-delivering this complaint letter, and we'll dismiss you for gross misconduct. He appealed and wasn't successful. So off we go to the tribunal, and his claims were unfair dismissal, wrongful dismissal, which is not paying notice, and they didn't pay notice because they classed it as gross, and sexual harassment on the grounds of gender, and he also brought age-related discrimination claims as well. So back to our answer, which is calling someone a bald something horrible harassment on the grounds of sex? And the answer is yes. The tribunal said those references, including the word bald, were unwanted and violated his dignity and created a particularly hostile and offensive, intimidating environment for him. And the tribunal, in fact, referenced their own baldness, 3 bald men, as referencing that this was definitely something that would be more likely to affect men than women, and therefore had a gender-related inference to it. And in fact, they said, you know, being called bald is inherently related to the male gender. His claims for age discrimination failed. So clearly the tribunal felt that you might be bald at any age, but they definitely said that it was gender related. So what do we learn from that decision? Well, of course, every case turns on its own circumstances, but I think it's a useful reminder for how broad harassment can be, and how many things might cause someone to feel upset and intimidated at work. I mean, obviously, we've got a row here with some threatening language as well. But, he gets home on sexual harassment because of the word bald being used in that example. So we've got to make sure we've got good policies, that we educate people, that we train people appropriately. And there was a case a few years ago, LA UK Limited and Gellin, I think I mentioned it last year, which talked about the quality of training, not giving a broad brush, answer a few questions and you've been trained is not appropriate. It should be, regular, it should be refreshed, it should be specific, and it should leave people knowing how to behave. So an interesting first bald case I think we've had. Moving on, we're going to look at a PIDA case, a Public Interest Disclosure Act case, also more commonly known as whistleblowing next. And this is Kong and Gulf International Bank UK Limited. And Mrs. Kong had raised some concerns about some potential regulatory breaches regarding the bank and its offering on investment services. The kind of detail doesn't matter, but she had some serious concerns about regulatory breaches. And obviously, when you raise those kind of concerns, they fall within our whistleblowing legislation. And in raising those concerns, she ended up questioning the professional ability and awareness of the head of legal for the fact that they hadn't spotted the issue sooner. And the head of legal found the way and what she said was offensive. And because of that, Mrs. Kong was eventually dismissed. So she wasn't dismissed for raising issues. She was dismissed in what she said and how she said it. Now, she claimed her dismissal was therefore automatically unfair because of the connection to the whistleblowing issue. And something is automatically unfair where it's for one of the prescribed reasons that you can never dismiss someone. And whistleblowing is one of those, as is discrimination. So that also brings people unlimited compensation. That's another advantage of an automatically unfair dismissal. So the tribunal firstly had to decide, was the reason for her dismissal the whistleblowing, in which case she gets home on automatic unfair dismissal, or not? First question. And in this case, the tribunal decided that it wasn't by reason of her whistleblowing. The decision to dismiss her was purely related to her conduct towards her colleague in the way that she'd questioned their professional competence. And the tribunal found that that was distinct and properly separable from the act of making a protected disclosure. The next question is, have you been ordinarily unfairly dismissed? So we've got two concepts, automatic unfair dismissal and then ordinary unfair dismissal. And in that circumstance, the tribunal found she had been unfairly dismissed. So the only difference here is the unlimited compensation point. But it's a good reminder that, what's the saying? It ain't what you say, it's the way that you say it. That if someone behaves inappropriately, regardless of what they're communicating, that could still be regarded as a conduct issue. In this case, it was decided that she hadn't behaved inappropriately, such to warrant dismissal. The current cap for unfair dismissal claims, so the maximum you can win, is a year's gross pay, or 93,878, whichever is the less of those two sums. That will go up this April. So that's the cap on ordinary unfair dismissal. And as I said, there's no cap on automatic unfair dismissal. But always take advice on whistleblowing issues, especially if you're considering dismissing someone after they've raised an issue, because obviously it's something you would be very careful about. Okay, we've got a second poll question coming up here. Is without prejudice the same as off the record? And let me have a look at what we said. So 26% of you said yes, it's the same thing, and 74% said no. So very much the majority saying it's not the same thing. And the majority have it on this example. Saying something is off the record, which people say far more often, I think, than they should, rarely results in what is being said as being kept off any record. So if you think that brings you any protection, the answer is really it doesn't. There are different ways to have discussions that are free from the risk of what is being said being later used in evidence in a court or tribunal if there's a dispute. But saying this is off the record is not one of those ways that would protect you. The options are the without prejudice rule, and without prejudice prevents statements or documents that are created or said in a genuine attempt to settle a dispute from going towards a court or tribunal as evidence in proceedings. Excuse me. So without prejudice will do that as long as there is a genuine dispute in place that's pre-existing the conversation. So without prejudice only applies where there's a pre-existing and genuine dispute to settle. We can also have something that's called protected conversations. And this was something introduced in 2013. And these conversations are used where there isn't a pre-existing dispute, but the employer or employee is considering the termination of employment in exchange for a compensation payment. So either employees can ask for a protected conversation, or an employer can start a protected conversation. Normally, if they wish to avoid a drawn out long process, and or if the reason for dismissal isn't one of the potentially fair reasons. So there are a couple of things you can do, but again, be careful, use a script, make sure if you want to rely on without prejudice, because of course, discrimination can't be protected under the protected conversation route, that you've got a pre-existing dispute that's genuine. Okay, and that's the reason that I want to mention this next case, Garrod and Riverstones Management Limited. And this was an employee who was employed as the company secretary, and she came back from maternity leave in 2019. And shortly afterwards, she announced to her manager that she was pregnant again with her second child. She then says she was treated in a discriminatory manner. And on the 30th of October, she raised a grievance complaining about that mistreatment and cited pregnancy and maternity discrimination, as well as bullying and harassment. A meeting then took place by their HR and employment law advisor, and Mr. Sherrard enters the scene, and he has a conversation with Mrs. Garrod, which he classes as a without prejudice discussion. Now, he didn't explain what that meant, and she didn't ask what it meant. And he went on to say that the relationship was fractured and had become problematic, and that the company would like to offer to terminate her employment in exchange for an £80,000 settlement agreement. However, settlement was not reached, and so the conversations ended, and she continued with her grievance, which was rejected. So after that, she resigned and went to the tribunal for all these claims, the maternity and pregnancy, sex discrimination, harassment, and unfair constructive dismissal. And what she wanted to do was include the without prejudice conversations, because she said that the way that was conducted was, rude and was unacceptable, and had added to her upset, and was Mr. Sherrard had been intimidatory and aggressive in how he'd presented himself. So the big question was, do we as the tribunal get to hear these without prejudice conversations? And they decided no. And she appealed to the EAT, and they decided no. And they said the reason is because there was clearly a pre-existing dispute at the time. And there's been previous case law about grievances that has said a grievance is not a pre-existing dispute. But this case says, well, sometimes it can be, and you've got to look at the individual issues. And in this case, she had raised her grievance with using terms like action before a tribunal claim. She'd referenced going to ACAS for conciliation. So it was clear that she had litigation in mind. And for that reason, the court said the without prejudice banner could apply. But there would equally be another grievance that wasn't evidence of a pre-existing dispute and just a workplace grievance, and therefore it would not apply and the conversations would be disclosed. So again, need to be really careful, take advice if you're unsure. I would definitely follow a script if you're going to have protected conversations or without prejudice conversations. You know, I think there's lots to learn from this decision, but the main one is a reminder that we should know what the rules are if we're going to rely on them. And secondly, you know, be clear in our conversation and any documentation about what protection or cover there is, if any. Okay. Ponticelli UK Limited and Mr. A. Gallagher is the next case, and this is a TUPE case. Mr. Gallagher's employer had inherited rights and liabilities for him and a number of other staff when they transferred over from their previous employer. With their previous employer, they had enjoyed a share incentive plan or a SIP. But prior to the transfer, they were told that that would not be present when they transferred over. The new employer did not have such a scheme. And he eventually brought a claim to say, you're obligated to create a scheme, because under the TUPE regulations, the Transfer of Undertakings Protection of Employment regulations, it protects my terms and conditions. Everything transfers with me. It's as if I had always worked for you. The argument in return was, well, this SIP is voluntary and it's not referenced in your contract of employment, and therefore there's no obligation to provide it. However, that argument failed, and the tribunal decided that he did have the right to an equivalent scheme created after his employment transferred with the new employer. So he was entitled to have access to a scheme substantially equivalent to that which he had enjoyed before. So this is a really interesting point. You know, how far do you go to replicate the terms and conditions and benefits that are available to people? And this case is pretty clear that you go a long way to do that. The one good thing, I think, with this case is that the Employment Tribunal did make an observation that's useful. And it said, I'm going to quote it to you, it's recognised by courts and tribunals that problems frequently occur when trying to match schemes, such as profit sharing schemes, on a transfer. And so I would suggest that where such a scheme exists, then steps have to be taken to reach agreement as to what terms an equivalent scheme will offer, or to buy out such a benefit with a suitably worded settlement agreement. So there are options, but it obviously adds to the burden that comes with TUPE already. So a really interesting one, I think, about just how far, and the fact that something isn't contractual would make no difference to whether it should appear in the new employment. You know, it was clear the SIP was there because of his employment, and TUPE covers things that arise in connection with employment contracts. So whether it's stated in the contract or deemed contractual or not, it's there because of someone's employment contract. TUPE is always an interesting issue for organisations. And then I want to talk to you about Chell and Tarmac Cement and Lime Limited. And although party and work function cases can often be quite entertaining, you know, think people and alcohol making fools of themselves, some Christmas parties or nights out can go beyond stupid and end up with something really dangerous. And that's what happened in this case. But the issue here is, but who's responsible? So who is liable and responsible when things go really horribly wrong. And that's called vicarious liability, or the concept of it is vicarious liability. Is the employer liable for what its employees do? So in this case, this wasn't a Christmas do, this was just in the workplace. And Mr. Chell was on site when one of Tarmac's fitters, Mr. Heath, had some tensions with him. So there were some arguments and disagreements between these two gentlemen. And as a result of this, Mr. Chell had made some complaints to his supervisors, but nothing formal had happened. On this particular day, Mr. Heath, however, decided to put 2 pellet targets on a bench right close to Mr. Chell's right ear, and then he whacked them with a hammer. And this caused a really loud explosion. And as a result of this, Mr. Chell suffered a perforated eardrum, noise-induced hearing loss, and tinnitus as well. So some really serious injuries resulted. It was argued the pellet targets were personal items, but the hammer was work equipment, and this was on site during the working day. So who is liable for damages for this injury? And the decision of the court in this case was that it should not be the employer. And the reason for that is that Mr. Heath was not acting in the course of his employment. You know, hitting pellet targets with a hammer was not an activity assigned to him or that Tarmac undertook. That was not part of his work, and it was a prank, for want of a better description. So there was no breach of the duty of care, and Tarmac are not liable or responsible. And Mr. Chell appealed this, but the High Court upheld the decision, and he appealed again to the Court of Appeal, and they upheld the decision as well. Just simply insufficiently close connection between the wrongdoing that caused the injury and the work he was employed to do. And really, there was no way to have a foreseeable risk of that kind of injury. So there was nothing the employer could do to have avoided that, because why would they think someone would engage in such dangerous, horseplay or activity, or, whatever you want to call it. I think it's good to always have, very broad policies about behaviour, make sure that people know it's and understand that kind of thing, practical jokes, anything like that, is not acceptable. It should be clear in health and safety policies what we should and should not do. But really, there's not much more an employer can do than that. So Mr. Chell was unable to show that the employer was liable. This is a similar case, actually. I know we're a long way off Christmas parties, but this is Shelbourne and cancer research, and it's a similar example. This time we've got an employee who's drunk and dancing and starts lifting up staff as part of his, I don't know what the dance is, but as part of his dancing. And he lifts one person, Miss Shelbourne, and because he's drunk, he drops her when he loses his balance and they all fall down, but she sustains serious back injuries as a result of this. And again, she wanted to sue her employer rather than him individually. And again, that failed. She appealed, that failed. So very similar circumstances. And in this case, cancer research didn't deny that it owed a duty of care. The denial was the extent of that duty and whether they had breached their duty of care and in turn, caused her injury. And the court said no. In fact, in this case, she argued that before a work function where alcohol is served, there should be, a written declaration signed by all attendees requiring them to behave in a certain way, that there should be risk assessments encompassing all eventualities stemming from such inappropriate behaviour, that staff should have actual training before they go to a Christmas do, special training for those organising it. And in relation to all of these, the judge said, as a matter of common sense, none of that can be right. you know, people would not regard, Joe Blogs on the street, if you like, would not regard doing all of that as socially appropriate, a socially appropriate set of requirements or obligations when you organise a Christmas party. So all of that was deemed to be a step too far. Next is Hedger and the British Deaf Association. This is a flexible working case. There are so many flexible working cases. You know, one thing that COVID definitely did was increase the number of people asking for permanent flexible working as a result of probably temporary changes that took place in COVID. But anyway, in this case, Miss Hedger started working for the British Deaf Association in 2014, and she worked 28 hours a week over 4 days. She went on maternity leave, came back from having her baby and made a request for flexible working, and she eventually resigned when that request was refused. And she made a request to, in order to balance her childcare commitment, she said she wanted to reduce her hours from 28 to 16 and work those 16 over 2 days. She suggested that the person who'd covered her during her maternity leave should be retained and they could job share. Her request was rejected. She made an alternative suggestion as part of that flexible working discussion, said she could do more hours, but over 3 days. That too was rejected. And to cut a long story short, the employer said, look, the only thing we'll agree is what you already do, 28 hours, and we'll let you do that over 4 days, but we will have to decide what the 4 days should be. Now, they gave no good reason to turn her down. They didn't look into the job share, being able to balance what she needed with what they needed. And in the end, she brought claims of sex discrimination because they just weren't willing to agree her flexible working request. And she won her case. And the Employment Tribunal said, you know, that if you demand something from women returning from maternity leave, that causes disadvantage, as they are more likely to have childcare issues and costs that go with that. And the tribunal was satisfied that she was at a particular disadvantage by the refusal to allow the flexible working, and that they did not have good reason to turn her down. So, you know, another decision where an employer doesn't try hard enough or have the evidence that says, we can't agree because this would be the impact, or we can't agree, we've tried to get someone to job share with you and we're unable to do that. You know, you have to have good evidence when you turn someone down. An outright refusal to consider anything other than the original 28 hours was not a proportionate decision. And also they were really judged negatively because they didn't consider a trial period. And remember, when she revamped her request slightly, it was to 24 hours. That's only 4 hours different. And the tribunal said, why wouldn't you have a trial period to see whether that would work? So the lack of adequately considering these alternatives, the lack of a trial period, and the lack of evidence of reasons to turn her down was their downfall. So lots of, you know, important reminders about getting flexible working requests right. Obviously, when people make a request in connection with maternity leave or being, you know, caring for children, for example, you've got the whole sex discrimination piece that goes with it. And I think in the end, she got about £36,000 for her compensation. Okay, just a couple more, and then we'll have finished that first section. So this case with Iceland Foods is a process and procedure case. And typically, if an employee is successful at an appeal, then they're reinstated. So if you're dismissed and you appeal, what you're saying is, I want my job back. And if you get reinstated, you get your back pay and off you go, all is good. If there is no dismissal because you've been reinstated, then you can't claim your dismissal was unfair. So appeals are really important things. So in this case, she was part-time assistant in one of Iceland's branches. She's dismissed for some allegation of gross misconduct. She appeals, and during the appeal process, she makes a subject access request. And as part of the documentation that arrived when she made that request, she decided, whatever it was, that she didn't want to return to work anymore. So she changed what she was pursuing from reinstatement to an apology and compensation. Now, that wasn't part of the disciplinary appeal process. I don't think I've ever read that in anyone's disciplinary procedure. You know, what you get is your job back. So that's, you know, and normally some other kind of warning. So in this case, halfway through the appeal, she says, I don't want my job back. I want compensation and an apology. She attends the appeal meetings. They decide to reinstate her and replace dismissal for a final written warning. She says, but I told you I didn't want to come back. And when she doesn't return to work on the date she was advised to come back, they then dismiss her for gross misconduct for failing to return to work. So off we go to the tribunal. And the tribunal says, well, the first thing we need to decide is whether you've been dismissed. And their decision was that she hadn't been dismissed because the reinstatement vanishes the dismissal. So they held that they had simply no jurisdiction to consider any unfair dismissal complaint because she had not been dismissed. She went to the EAT, the Employment Appeal Tribunal, and her appeal was also rejected there. And they said, look, the fact that you said, I don't want to return to work is a matter for you, but you continued with the appeal process, and the only appeal outcome available was a return to work. If you didn't want to have your appeal considered because you didn't want to return to work, you should have withdrawn from the process, and you didn't do that. So if you don't withdraw and continue, it doesn't matter what you say, the outcome, or the best outcome, will still be reinstatement. And if you participate, then it's on the basis of the outcome that's available in the disciplinary appeal process. So if you definitely don't want to go back, there's no point appealing, because it's a good strategic step actually to reinstate someone. The big loss if you don't appeal is that if you bring an unfair dismissal claim, the tribunal might take away a percentage of your compensation for failing to follow the company's policy, which includes an appeal. But if you've got good reason why you don't follow it, you know, if, for example, there's no point because I've discovered documentation that shows the relationship is beyond repair, then the percentage reduction will be minimal or not at all. But for the employer, the power is in the process. You know, this is why appeals are really important. They can put right what's gone wrong in earlier stages of the process as well. Okay, and I think this is the last one, and then we'll have a break. So this is a bit of a cautionary tale about lies and CVs. And in this case, which is R and Andrews, in 2004, Mr. Andrews got the job as Chief Executive Officer of a hospice. And he got the job because he made a number of false and dishonestly inflated, misleading statements, all about his education, qualifications and experience. And in fact, on his application form, he claimed to have degrees from Bristol University, from, I think he had a second degree from, again, from Bristol University. He said he had an MBA from Edinburgh University in management science. He said he was studying for a PhD in ethics and management from Plymouth University. He had all sorts of professional qualifications, you know, an advanced diploma in management accounting, and none of it was true. Also, with regards to his employment history, that was mostly fiction as well, just endless lies and misrepresentations. Anyway, he got the job, and he held the job for, I think it was 11 years, 2004 to 2015. And his starting salary on joining was £75,000 a year. Then he applied for some other remunerated positions in an NHS trust and somewhere else. Then he said, oh, I got my PhD now. And he asked his colleagues to start calling him Dr. John Andrews. I mean, there's taking it too far. Anyway, eventually this house of cards started to fall down, and all his employment and other remunerated appointments came to an end when the truth about his lies emerged. He was obviously dismissed, but he was also prosecuted, and he pled guilty to 3 counts of, obtaining financial advantage by deception and, all sorts of other false representations under the Fraud Act and so on. And he was sentenced to 2 years imprisonment for those offences. But let's not forget, he also had substantial earnings based on these, the series of lies that he told. So there was also a confiscation order made in respect of the 10 years worth of earnings. So I think it netted to something like £643,000. And they decided that they were going to recover the difference between what would have been a relevant amount of pay to have paid him for what he did and the money he received. So really interesting case. Think twice before you lie on a CV. If you get found out and you lose your job, that might not be the worst thing that can happen. That the worst thing is still to come, potentially. It's a difference between saying I'm amazingly self-motivated and saying I have 3 degrees and a PhD that you don't have, obviously. Okay, so that's just a few cases that I thought were interesting, general interest. We'll take a break now. It's just after 10 o'clock. I'll have a look at your questions while we have a break. But let's take 15 minutes and come back at 10:15, if that suits everyone, for a comfort break, and we'll move on to the next section then. Okay, so that's a few cases from last year. Let's move on. So, the next section for us is to look at this year, and I think this year has the potential for some major changes. Whether they'll come into effect this year or next year will wait to be seen, but there's a fair amount being shaped and fleshed out in the background, from kind of post-Brexit reform agendas to a series of private member bills that are being government backed. So in a minute, we'll have a look at what's in the future. Just picking up on some of the points that have been raised, Simon, I think probably some of those questions we talked about in that Burke case, but certainly I think occupational health should always be independent, because they should have the best interests of the health and safety and ability to work of the people that they're assessing. So there should be that independence. I think that it's an interesting point, because they're paid for by the employer. I do lots of investigations and coaching and mediation and all those kind of things, and often it's said, but you're not really an external independent person because the employer's paying. But if you ever asked whether an individual wanted to pay part, I'm pretty sure they would say no, but the obligation is still to make the right decision. The other point you made, which was a good one, was about consultants' opinions. And I think the more senior the doctor or the medical practitioner, the more likely it is that it would influence an occupational health assessment. So certainly it could change, alter, or would certainly be something an occupational health specialist would want to take into account. We did actually have a question submitted in advance of the webinar. That's probably now's a good time to pick up on that. And it was a question about when does somebody need to self-certify when they're absent, and about triggering sickness absence policies and what does that mean. So the self-certification is something that employers often ask for, because a fit note is not required until someone has had 8 or more days absence. So a self-certification form is something that's an internal document to an employer that they use to record someone's absence and the reason for it. And the fit note, as I said, is from 8 days onwards. And there was a change recently with fit notes in that they can now be given by a far wider group of people. So healthcare professionals that can issue a fit note include doctors, nurses, occupational therapists now, pharmacists and physiotherapists. So the group has widened substantially. And when a fit note is provided, it has 2 boxes to tick. One that says not fit for work and the other one that says might be fit for work. And if the might be fit for work box is ticked, then it leads to a number of other points that come into play, things like a phased return to work, or some other adaptations that would allow that person to return to work. Then the second part of the question that was submitted was about triggering absence policies. And absence policies are something that most employers have. And quite often there are different triggers for different actions contained within the policy. So the trigger is often not, how many days sickness in maybe a rolling 12-month assessment period, or the number of spells of absence, or some triggers relate to the reason for absence. If work-related stress is mentioned, that might trigger a referral to an occupational health advisor, for example. Some companies use something called Bradford points. I don't know if any of you have heard of that, but this is an assessment that applies really to intermittent, persistent, short-term absence. So it's the number of spells squared times the number of days taken as absent, and that produces a number, and the trigger might be, absence of X number of Bradford points and above triggers the policy. And when we talk about triggering the policy, what it does is it triggers actions. So quite often if someone triggers, they've had 7 days absent in a 6-month period, for example, that might trigger a meeting with their line manager to discuss their absence history. And there might be a trigger that says, if you've had, 4 or more spells of absence, that might trigger a formal meeting to discuss your absence. So there's lots of different things an employer can do with absence triggers. Often they lead to warnings and a requirement to improve someone's attendance. Whether someone's genuinely ill or not makes no difference to the triggers, because the triggers isn't about whether we believe your absence is genuine. The trigger is about the attendance and how that might be improved. The only other thing to bear in mind with triggers is that if somebody has a disability, then it could be a reasonable adjustment to amend those triggers. Some organisations will extend the triggers when the absence relates to disability. So instead of 10 days sickness or more, it might be 20 days sickness or more. So again, you would look at the individual circumstances and see whether or not a reasonable adjustment, which might include the trigger, would be relevant for that person. So hopefully that answers that question as well. But when we get to our next break, I'll check in again and see if there's any more that I need to answer. So let's go on and look at what we've got in store. So the first thing I want to talk about is changing terms and conditions of employment when employees don't agree. So there is a process that's commonly known as the fire and rehire process, where if an employer wants to make alterations to terms and conditions of employment when the employees have not agreed to those changes, they can give notice to terminate employment and at the same time offer re-engagement on the new terms that they want to bring in, hence the fire rehire label. To be successful, that change has to be preceded by 3 steps. The first one is that an employer has to identify that they have a sound business reason for wanting to make these changes. So that's number 1. Number 2 is a fair process must have followed, including genuine consultation. And number 3, if agreement cannot be reached as part of that process, as a last resort, the employer might consider dismissing those that have not agreed by giving due notice and then offering them immediate re-employment on the new terms. So that process, the government has decided, needs proper code of practice to support how it should work in practice. And ACAS has already produced some guidelines or advice on this concept. And this all became a big focus because of the P&O mass redundancies, where we saw them. I think they sacked nearly 800 of their staff without proper process. So the new code that's being consulted on will make it explicitly clear to businesses that they must not use threats of dismissal to put pressure on employees to accept new terms. So if you started the process by saying, look, if you don't agree, we're going to fire and rehire you all, then that's the threat of dismissal being placed right at the beginning of the process. So instead, the process should be fair and transparent and propose changes for which you seek agreement. So, I understand why this is being done. The teeth to this is really that if an employer doesn't follow the code and employees bring unfair dismissal claims and win, then there will be an increase of up to 25% in the compensation awarded. So the code will have some teeth, but to be honest, if you followed a fair process to start with, the code would make no difference to how you deal with changes to terms and conditions of employment. So it's worth looking into that if ever that's something that you need to do. And as I said, the consultation is still ongoing at the moment. But if you want to look at what it's likely to be, ACAS has a code and has guidelines already published on their website. Excuse me. Next, I want to talk about the fact that we've waited a very long time since 2019 for the government's employment bill, but it pretty much looks like now it's vanished. So I've talked about it since 2018, actually, that we've got this employment bill on its way. But no, instead, we seem to now have a number of private member bills that are government backed, most are, to implement some of the promised changes that the employment bill was going to bring in. So we're going to have a look now, no longer at the employment bill, but at these separate government-backed private members' bills that are making their way through Parliament. They may enter the statute books in 2023, but implementation may not be until 2024, so it might not be until next year, but we will watch this space. So the first one to mention is the Protection from Redundancy, Pregnancy and Family Leave Bill. And under this new proposed legislation, expecting employees will receive greater protection from redundancy during their pregnancy, and new parents will also have extended protection when they return from adoption and shared parental leave and maternity leave as well. So let's look at the current position. At the moment, we've got the maternity and parental leave regulations of 1999, and they set out an obligation to offer suitable alternative employment where a vacancy exists to a person on maternity leave when their job is at risk of redundancy. And failure to make a suitable offer of employment under Regulation 10 may result in that redundancy being automatically unfair. So essentially giving rise to a discrimination claim on the grounds of pregnancy and or maternity. And the period of protection under Regulation 10 is limited to the duration of maternity leave. So it offers no protection once an employee has actually returned to work. And the reason for this change is that there are concerns that in a bid to avoid the protective nature of the current regulations, some employers wait until a woman on maternity leave returns in order to implement redundancies and therefore not have this Regulation 10 come into play. So the government has proposed under the bill some new changes, excuse me, that says that the protection period for redundancy protection will be extended for expectant employees from the moment they inform their employer that they're pregnant right through for 18 months. And therefore, a woman who takes, maternity leave less than a year would have protection once she returns to work. And that could be protection for a number of months on the return to work. So big change in the period. Secondly, a woman who experiences a miscarriage would also be protected, and this time for 6 months after their pregnancy ends, or until the end of any leave entitlement if they take time off. Similar provisions will also apply to those adopting a child or taking shared parental leave. So, as I said, the bill is going through Parliament. It's unclear whether it will definitely come into our statute book, and if so, when it would take effect. But, I think more likely 2024. So that's the first one. The second one I want to mention is called the Worker Protection, open brackets, Amendment of Equality Act 2010, close brackets, bill. And this, we've moved from redundancy protection to harassment protection. So this is about worker protection. So if this bill is passed, it will firstly place an obligation on employers to take reasonable steps to prevent employees from suffering harassment in the course of their employment from third parties. So we used to have third party protection, but it was repealed and removed a number of years ago. So this is bringing that one back. So this is protecting people from customers or clients or members of the public. And then secondly, so that's the third party element. Secondly, it will create a new duty on employers to take all reasonable steps to prevent sexual harassment of employees in the course of their employment. Okay, so specific to sexual harassment and specific to taking all reasonable steps. So if the latter is breached, there's the potential for an uplift of up to 25% in any compensation awarded in a sexual harassment claim. So this really shifts the focus from reacting to issues to being proactive in preventing issues. And it obviously revives the liability for third-party harassment too. So again, back to what's in our policies. Do people know about them? How do we educate people? What's our training? Are we jumping on issues and dealing with them quickly and appropriately? Are we behaving in a way that encourages people to respect what our policies say? So next, I want to talk about, third one is the Employment Relations, open brackets, Flexible Working, close brackets, bill. So this is to extend the flexible working legislation that we already have. And once passed, this bill will further enhance people's rights to flexible working. So 4 principal changes. Firstly, this bill will extend the number of flexible working requests an employee can make in any 12-month period from 1 request to 2. So it doubles the number of requests that someone can make in a year. Secondly, it changes the flexible working regime to also introduce a requirement for employers to properly consult an employee before they reject the flexible working request. Now, I think that one we should be doing anyway, but it will bring in a requirement for genuine consultation prior to rejecting a request. And that will include discussing alternatives, because that's what consultation will include. Thirdly, it reduces the employer's decision period from 3 months to 2 months. So it speeds up the process. And that has to include any appeal if an appeal is offered. So it requires a much more succinct and quicker process. And then lastly, it removes the requirement that an employee must explain what impact or effect the change they are proposing would have on their employer and how their employer might want to deal with those with that impact. Okay, so it takes away the requirement that we can ask people to say, well, what effect would this change have on what you do and us as an organisation, and how do you propose we overcome any difficulty? And then finally, as it stands currently, employees can only make a request for flexible working if they have 26 weeks continuous service. And separately from the private members bill I've just been talking to you about, the government has also committed to making the right to request flexible working a day one right rather than a 26-week or 6-month right. So someone can join and on their first day ask to work part-time. So this obviously has significant changes for a workplace, and we'll wait and see when and if they come in. I think it's very likely, though. This flexible working one's been talked about for a while now. And I've just put on the next slide just a reminder that it's, you know, a right to request, not a right to have, but there's only a limited number of reasons that we can turn a request down. And I've put them up on the slide for you there. And they're all very logical, you know, extra costs that will be damaging, or the fact that we can't recruit people to do the work that, you know, you're no longer available to do, for example. So you can read them for yourselves, but they're pretty logical reasons. But as we heard in the case I discussed with you earlier, you've got to do more than just say, oh, that's going to cause, you know, customer difficulty. We won't be able to do that. You know, where's the evidence? Where's the effort to overcome any difficulties? Okay, next I want to talk to you about the Employment Allocation of Tips Bill. And once passed, this bill will create a legal obligation on employers to allocate all qualifying tips, service charges and gratuities fairly between their employees. And employers, as part of this bill, will also be required to implement a written policy that clearly sets out how it proposes to allocate qualifying tips amongst its employees, and, you know, what records it's going to keep, what records it will share, you know, how the allocation will take place, all those kind of things. But the bill will only apply to tips an employer receives or exercises control or significant influence over. So really, it's unlikely to catch, you know, cash tips paid directly to workers. So clearly there's a need for, you know, openness and transparency when it comes to tips, and this is going to be really welcomed. In fact, I was talking to my teenage son about this, who spent his gap year working in a restaurant and moaning about the fact that you didn't get to keep any tips. But, you know, there's no change overnight. So we expect the new rules will probably not commence any earlier than at least a year after the legislation has passed. So employers have, you know, sufficient lead in time to change their practices. But there you go. People can do it in advance of the legislation, of course, if they wanted to. Next on the list is the Neonatal Care Leave and Pay Bill. And if this bill becomes law, it will mean that all employed parents will be entitled to up to 12 weeks of neonatal leave if their baby receives neonatal care for a week or more. So it applies to newborns up to the age of 28 days who are admitted to hospital and are required to have a continuous stay in hospital of 7 full days or more. And this one's also going to be a day one right. You won't have a minimum period of service to qualify. So this means that, you know, parents who join and, you know, has a partner that's pregnant or whatever would have this right, or if the woman joins and is pregnant and has a neonatal care requirement, then it would apply from day one. So the idea that sits behind this is that the leave won't actually be taken until after maternity and paternity leave has passed. So there will have to be a set period in which the neonatal leave and pay must be taken. And the last I read was that it would need to be within something like a 68-week window following the child's birth. So it's expected that the leave will tag on the end of other leave. And the bill also provides employees with the same protection that we're used to from dismissal or detriment because they've taken this leave, and that applies to all the different parental leave rights people have. The only way that 26-week service comes into play with this potential legislation is that you won't have any entitlement to any pay for the time off unless you have 26 weeks or more service. And in that case, it will be at the prescribed rates that we're used to for statutory maternity pay and statutory paternity pay and so on. So I think at the moment that's £172.48 per week. So if you've got 26 weeks service, you can have the statutory pay. If you have less, you still get the leave. Okay. So that's neonatal. And then we've also got carers leave, the carers leave bill. And this one started in September 2021 when the government published its response to the consultation and confirmed that it does plan to legislate an entitlement to carers leave for employees. So once passed, and this is expected to be passed in 2023, it will give the following rights. Might not take effect until next year, but it might pass this year. So again, it's a day one right, carers leave. The leave will consist of 1 week, which is 5 working days of unpaid leave per year for those employees with long-term caring responsibilities. And the leave can be taken to provide care or arrange care for a person with a long-term care need, whether that's illness, injury, or old age. And similar dependence rules are likely to apply that we already have. So it will cover spouses, civil partners, children, parents, and so on. Booking rules will be similar to annual leave notice under the working time regulations, which I mentioned to you earlier. So in order to take time, you will have to give twice the amount of notice for the leave that you want to take. And there will be the ability to turn down a request if an employer would be unduly disrupted by that person having that time off at that point. So this is about sort of planned care or making arrangements for care. It's not about an emergency type situation. We've got other leave for that. So this is about a planned leave. And there's no limit to the reason for it. And in fact, it's a self-certification of eligibility. So you won't have to give a reason that you want the time off. But anyway, let's wait and see what the full rules look like when they come in. But certainly no evidence of the requirement will be there. And it may be that the days can be taken as single days or half days. So a bit to find out what the final bill would look like, but certainly some flexibility will be in there for carers. Then this is the consultation that we had on post-termination non-compete clauses in contracts of employment. And this was started a while back. I think it was in December 2020 that the government started consulting on post-termination non-compete clauses. And the two principal options in the consultation for what the legislation should look like is either option one, which would make those post-termination non-compete clauses only permissible where the employer provides compensation, like a percentage of basic pay, for the period that somebody would be restricted or prohibited from working for a competitor or starting their own competing business. So option one is saying you're going to have to pay if you want to restrict where people work. And option two is to make all post-termination non-compete clauses void and unenforceable. So the consultation actually closed on the 26th of February 2021, but there's been virtually no update on the response. And the last I heard was that the government is still in the process of analysing responses to the consultation and the available data, and any decisions will be published on the gov.uk website in due course. So no idea whether this has gone away or whether we will hear more this year. So for now, non-compete clauses remain as a tool available to an employer if they want to fairly and appropriately protect their business by restricting where people work and for how long. Obviously, this is all in the drafting as to whether they will stand up or not. So if you want a non-compete clause to work, I would take good advice on whether it's too broad, whether the geography of it is too broad, whether the timing of the restriction is too long, you know, how it's worded and so on, because for every case that does get protected, there's a case where it fails and the non-compete doesn't work. So worth looking into carefully if you want to use them. Can't really have an update without talking about trade unions and strike action, and what a year it was and continues to be. And in response, the government introduced new legislation last year, but they also are proposing new legislation for this year, and that's in the form of the Strikes Minimum Service Levels Bill and the Transport Strikes Minimum Service Level Bill, which are still making their way through Parliament. So basically, they would restrict workers in transport, health, fire, you know, ambulance, education. They would restrict certain sectors and require them to work to some extent during strike action, which would allow employers to deliver a minimum service. So these are really controversial measures, and challenges are expected by the trade unions. As I said, there was legislation brought in last year, and that's currently back in the courtroom at the moment because the High Court received and granted permission to the TUC and Unison, and I think some other unions, to launch a judicial review to challenge the legislation that came in last year. And that was the Conduct of Employment Agency and Employment Business Amendment regulations. And those regulations did take effect from last July, and they allow employers for the first time to engage agency staff to cover employees who are on strike or participating in industrial action. So again, this did not go down well at all, because prior to that, you couldn't take on someone from an agency to cover a worker on strike. So we'll see what the judicial challenge brings, but whatever outcome we have, I think more strikes will continue throughout 2023. It looks set to continue in any event. Okay, then on the 3rd of February this year, the Department for Business, Energy and Industrial Strategy announced that it was going to support something called the Workers' Predictable Terms and Conditions Bill. And this is a bill that isn't government backed, it's a private members bill, this one. And that says that if a worker, and this includes agency workers, has an existing work pattern that lacks certainty in terms of hours and days and times, or if they're on a fixed term contract for less than 12 months, then they can make a formal request to change their working pattern to something more predictable. And this will be a right that requires a minimum of 26 weeks employment, and employers will be able to refuse the request on specified grounds. So a bit like the flexible working, there will be a number of reasons that you can turn down someone's request to have a more predictable or stable working pattern. But let's wait and see how far this one goes. I mean, if it goes ahead, it will be really interesting, because and they think that the same sort of flexible working reasons will actually apply to this legislation. You know, you might want a more predictable working pattern, but that's going to have a detrimental effect on our business success, or on our, we haven't got enough work in the period that you want to have as your regular working hours, and so on. So it'll be interesting to see how far or what happens with that one. Then one that we know is definitely happening is the retained EU law revocation and reform legislation. And this is probably the most significant development on the horizon. And it probably overshadows all the others to some extent, because this bill aims to speed up the removal of certain retained EU legislation by giving our ministers the power to scrap or replace it. Importantly, it also includes what's been called a sunset clause, meaning that automatically at the end of 2023, many of the retained EU legislation will disappear unless it's already been restated or replaced. Now, that's not far away, the end of 2023. There is the ability for this date to be extended, and to be perfectly honest, I think that's highly likely to happen, or the legislation is otherwise expressly changed, but I think the date is the most likely thing to extend. So this will affect a huge amount of our current UK employment legislation, including the working time regulations, TUPE, agency worker regulations, maternity and parental leave regulations. I mean, there's lots that's derived from EU legislation. So I think we should definitely expect the 2023 deadline to be extended, but it will be super interesting to see what will remain, what will change and what will go. Secretly, I wouldn't mind a bit of TUPE change, to be perfectly honest, but, you know, let's wait and see. I want to mention a couple of statutory rates of pay next. So the Department for Work and Pensions have published their proposed increases for statutory benefit payments, which will change in April. So statutory sick pay, currently it's £99.35 per week, and that will go up to £109.40. Statutory maternity, paternity, adoption, shared parental, statutory parental bereavement, maternity allowance, the raft of statutory rates that we have in that family-friendly group, they will increase too and go up from £156.66 to £172.48 per week. So all of those changes are likely to take effect. Normally it's the first Sunday in April, so in this case it would be the 2nd of April. All on the gov.uk website if you want to have a look at the latest. We've also got the normal changes to the national minimum wage legislation and the national living wage. So this is from the 1st of April, not the 2nd, and the national living wage is for workers aged 23 and over, and that will go up from £9.50 to £10.42 an hour. And then we see the other rates, apprentice rate will go to £5.28, 16 to 17-year-olds will get £5.28, same, 18 to 20-year-olds, £7.49, and the 21 to 22-year-olds, £10.18. So over 23, £10.42, 21 to 22, £10.18. Again, look up the numbers on the gov.uk website. So I remember saying this last year, but for different reasons, we've got an extra bank holiday on the 8th of May. This is to mark the coronation of King Charles III. So whether you will have to take leave for this extra day or be granted this extra day will obviously depend on the contractual wording in your employment contract. So we've got a few examples here. So example A, you are entitled to all bank and public holidays. So if the contract says you are entitled to all bank and public holidays, in any year where there's extra ones, you get them. So I think that one's really straightforward. If your contract says something like example A, there's no question you're going to be given the extra day off. Example B, you're entitled to 8 bank and public holidays, and that's what we normally get in a year. So if you have example B in your contract, then that means you don't get an addition, and if you want the day off, you'll have to take it as annual leave. Of course, some employers might be generous and say, we'll give it to you anyway. Example C, you're entitled to 30 days leave, which is inclusive of bank and public holidays. That, I'm afraid, is the same as example B. You don't get it as an addition, and you'll need to just use your annual leave if you want the day off. But there you go. It'd be pretty mean not to give it, but lots of employers won't. But you know, contractually, they may be obliged to. And then lastly, we've been talking about contractual wording a little bit. So I thought I'd give you a quick reminder of some of the protective clauses that your contracts might have and what they mean or might be missing. So layoff clauses, these became really helpful in COVID during the furlough period. So if there's a temporary shortage of work, an employer that has a layoff clause in its contract will be able to send employees home and lay them off without getting their agreement. So the layoff clause, is really to cover those unexpected issues, and it sets out what somebody should, what work they should or shouldn't get, how long that layoff will last. And then there's a small statutory payment, which is, I think it's up to £30 per day for 5 days if you have a statutory layoff clause. So great for employers, not so good for employees. Then there is pile-on clauses, payment in lieu of notice, which I think all of you will be familiar with. So this gives the employer the ability to ask someone to stay at home and leave early by being paid in lieu of their notice. So it should be expressly stated. It should also specify what pay they will receive. If it's silent on what remuneration someone would receive, then they should receive what they would be if they were not paid in lieu. But I've seen pay in lieu of notice clauses that say you will only receive your basic pay if you're paid in lieu of notice. So it restricts someone's employment period because they leave early, basically, and get their notice paid to them. Notice periods, I mean, an employer can specify, as long as it's not below the statutory minimum notice, how long they want to give someone for a notice period. The legal minimums are, if you have less than 1 month's service, there is no obligation to give any notice at all. And then after 1 week's notice up to 1 year's service is 1 week. And then that week goes up by an additional week for every extra year of service, up to 12 weeks notice when you've got 12 years service. Okay, so as long as you give above what the statutory minimums are, you can set pretty much any notice period you want. Then we've got restrictive covenants that we've just been talking about a little bit. So these are helpful for protecting commercial business interests. We often see anti-poaching clauses, the confidentiality agreements or post-termination restriction to where people can work. So I've mentioned that to you already, but if you want to use those, you need to look into how you draft them appropriately. Then there are garden leave clauses. This is where an employee is on their notice period, but you don't want them to be either at work or working. So basically they're being paid to stay at home and not do any work. So unlike a pay in lieu of notice clause, the employee is still employed, so they can't work for another employer during this time, but they're, otherwise they're free to do what they like. Mobility clauses, always good if you have reason that you want to move people around, or if you're thinking of relocating your business. It's sometimes invoking a mobility clause is an alternative to invoking a redundancy clause, for example, if it's all about the location. And then I see some contracts where people say you'll receive SSP, statutory sick pay only, if you're off sick during, for example, a grievance process or a disciplinary process or, a performance improvement process. So sometimes it's a tactic if you're in trouble to go sick and make use of sick leave and sick pay. But if the clause says, should you go sick during any of these situations, you'll get SSP only, that's a less attractive option. And then finally, deductions from salary. I think that's a good clause, general clause to have, if you want to recoup money, overtaken holiday pay, damage to property, parking tickets incurred in the course of employment, even, clawing back training costs. You can have lots of deductions from salary clauses. So hopefully there's a few examples of contractual wording that might be, beneficial for contracts of employment, things to look into if that's of use. Okay, it's nearly 11 o'clock, so we're going to take the second break which then logically gives us our last section. So again, if we take 15 minutes back at 15:15, let's keep it logical, makes sense. And then I'll pick up on any questions and then we'll do the final section. So thank you very much. See you shortly. Well, welcome back, everybody. You're on your final straight now. So just want to pick up on a couple of questions before we move on. So there was a great question from Julie, thank you very much, which was, what weight should an employer give to a fit note if it's signed by a pharmacist? Is a pharmacist more likely just to agree with what an employee says? And I think that's a really interesting question. And I couldn't get my head around the fact that somebody might wander into a high street Boots and say, could you sign me off for 3 weeks? So anyway, the guidelines do give a bit more information, and they say this was never envisaged for high street pharmacists, but rather for pharmacists within a doctor's practice or a hospital setting. So I think that gives a little bit more information, but the same regulations and guidelines, and you can see them on the gov.uk website as to what giving someone a fit note entails, what considerations need to take place, will apply regardless of who's issuing it. And then there was another question about how much is neonatal pay likely to be, and it will be another statutory pay rate, just the same as statutory maternity and shared parental leave and paternity leave and so on. So that's what's envisaged for that one. And then I've got another question, which is about notice periods. So the question is, if you're employed on a certain notice period, and let's say it's 3 months, can an employer change that contractual clause after you join the company and let's say put it up to 6 months? So can an employer change your contractual notice period? And we touched on this a little bit earlier when I was talking about the fire rehire process. It's another example of where an employer might want to change the terms and conditions of someone's contract of employment. So they have to go through the normal, fair process. You have to seek agreement. And if someone doesn't agree to that change, then your only option is to look at, have I got genuine business reason, going through a proper, fair, genuine consultation process. And then am I going to impose the change either by just making the change or to do the fire and rehire process? The thing to be aware of with this one is if you impose a change, so let's say you speak to someone and say, you're on 3 months notice, we want to increase that to 6 months notice, I'm sending you a new contract. If the person then does not sign the new contract, but they carry on working, that doesn't indicate their agreement, because it's something that isn't going to happen until some point in the future. If you sent someone a contract and said, I'm decreasing your pay by £3 an hour, here's your new contract. If that person, whether that person signs it or not, if they stay employed and don't complain, then they will be deemed to have accepted that change because it's an immediate change. But the same is not true for something that's likely to change in the future. So just sending a contract isn't enough to show that someone's agreed to that. If you ask for a signature, I always say to my clients, if you've asked for a signature, then get a signature or get an understanding as to why you don't have a signature. So yeah, that's the process that you would go through to change someone's contract. Okay, thank you very much for those questions. I'll try and pick up on any more at the very end as well. So we're on to our last section, which is to look at common myths. And I've picked a few that I hear as a consultant, I hear all the time. And people present them, as I said right at the beginning, present them as, as fact. So I think we've got our third question. Yes, our third question. So an employer can reject a candidate for a maternity leave cover role on the basis that she is pregnant and would not be able to work the full cover period. So if you remember, we answered, that's true, you could reject someone, and 48% said yes, and 52% said no, it's false, you wouldn't be able to reject them because they're pregnant. And the false 52% are the winners on this occasion, because an employer cannot reject a candidate for a maternity leave role just because they're pregnant. So case law has made this really clear. And in fact, it is really clear that if you treat someone less favourably because they're pregnant, it's not going to be lawful. So failing to recruit a woman because she is pregnant, even if you're trying to cover someone who's pregnant, would never justify unlawful sex discrimination. Okay, so that's actually a pretty straightforward point. And also you can't, the other one I hear all the time is you can't dismiss an employee on maternity leave. And the answer to that is, of course, well, you would think really carefully before you dismiss someone on maternity leave. But if someone goes on maternity leave and you discover that they've been committing, fraud and stealing from your business, and you've got it on CCTV and it's absolutely certain, then of course you would, go through the appropriate steps to terminate someone's employment. You can't terminate someone because they're pregnant, but you can terminate a pregnant person or someone on maternity leave. So there's definitely a difference between those two things. Okay, the next one I've decided that we would look at is a CPD question, everyone's favourite topic. So this is one I hear all the time. Oh, but after a year, it's entirely safe to vary contracts of transferred employees if you want to harmonise terms and conditions. So people present the idea that as long as a certain period of time has passed, then you can make changes. And that's just not true. Obviously, there's the guidelines say that you transfer with your retained terms and conditions, and there is no point in the legislation that it says until you've had another year or 2 years and then your employer can change them. The fact that you go across and you keep your terms and conditions is not time limited. That's a permanent change. So there isn't anything like a year or 2 years. Obviously, the longer a period of time is, the looser the link to the change being by reason of the CPD transfer. And often employers change everybody. So if you have 20 people that transfer into your business and you decide to make some changes in 5 years' time, if you make changes to everyone's contracts in some form or another, then it becomes less about we're homing in on you as a group because you had a CPD transfer. But, the passage of time in itself does not stop the change being connected to the CPD transfer. In fact, there was a Court of Appeal case a few years ago where someone successfully argued that a change in their terms and conditions 13 years after their CPD transfer was still connected to the transfer. So, there is no 1 year, there's definitely no 1 year, let alone 13 years. What the legislation does say, though, is that if you acquire employees as a result of a transfer, and they obviously retain their terms and conditions, there are limited circumstances in which you would be able to change terms and conditions, but they have to relate to something that's called an ETO reason, an economic, technical, or organisational reason for the change. So you can make changes to contracts. Again, you have to follow a fair process in order to present them and consult and all the rest of it. But if you want to make changes, you can improve terms and conditions without any difficulty at all. But if it is to be a detriment, someone that will end up being less favourably treated, then you've got to have one of those ETO reasons, economic, technical or organisational reason, that involves a change in the workforce. So if you're doing some mass restructuring and you're improving some terms and you're removing some terms, then you need to argue what's the ETO reason. And I've put some examples up there on the slide that you can have a look at. The change to the workforce must include either fewer people or a change in the work that people do. So again, there's some obligations there as well. To summarise, if you want to harmonise terms and conditions for people that have transferred, take some advice before you do it, because it can be quite expensive getting that one wrong as well. But it is possible in some circumstances. Okay, the third myth I decided we'd look at is this one. An employee doesn't begin to accrue service for the purpose of their statutory rights until they've successfully completed their probationary period. So in other words, there's this idea that the probationary period isn't really employment, it's kind of a pre-employment situation, and it's just not true at all. Probationary periods have no meaning in law at all. They're not mentioned in our legislation either. So the existence of a probationary period cannot affect a new employee's length of service or statutory employment rights at all. Statutory rights, including the right not to be unfairly dismissed, are dependent on minimum periods of service. The right not to be unfairly dismissed is 2 years, but that's from the start date, not the expiry of a probationary period. When it comes to employee benefits, so not statutory rights, but benefits, then yes, you might be able to take account of later dates. So it's not uncommon to say, we have dental care, which you would be able to join after the successful completion of your probationary period. I mean, that's fine. It's not a statutory benefit. The other similar one to that I hear is that employees with less than 2 years service have no rights at all. Again, that's just not true. They cannot bring an unfair dismissal claim, but they can bring an automatic unfair dismissal claim that we talked about earlier. They can bring breach of contract claims. They can bring holiday pay claims. They can bring discrimination, harassment, whistleblowing. There's a whole ton of claims that they can bring. So if you ever hear that one, people with less than 2 years service have no rights, that's definitely not true. Okay, fourth one, no employment contract exists if there's been nothing put in writing. Hopefully that one is an obvious one, but it's completely untrue. A contract of employment can be verbal and is just as binding. Obviously, terms that have been orally agreed are ripe for dispute at a later date, and it would be a mad employer who decides to put nothing in writing. But contracts don't have to be in writing. What everybody should have under Section 1 of the Employment Rights Act is something that's called a statement of particulars. And that's almost the content of an offer letter. So it should set out all the standard basic things that someone should know. The name of their employer, their start date, the amount of holiday, the amount of pay, all those kind of basic things. So if there's no contract, it doesn't mean that no contract exists. Okay. Myth number 5, one of my personal favourites. You cannot give a bad reference. Oh gosh, I've heard that so many times. Again, simply not true. Firstly, other than in some limited sectors, there's no obligation to give a reference at all to start with. However, if you decide to write a reference, then you owe a duty of care that's shared between the person you're writing about and the employer that you are going to send that reference to. And your duty of care is to both of those parties. An employer can only give a bad or unfavourable reference if they genuinely believe it to be true and accurate and have reasonable grounds for that belief. So if a reference is provided, then we need to make sure it's fair and it's accurate and it's not misleading. But if an employee stole from you, the example I used a bit earlier, you can say that in a reference. You know, it's true. My advice would always be to stick to the facts and avoid expressing, you know, opinions. To suggest that an employee is a great catch when actually they stole from you is going to lead potentially to a claim from the recipient of that reference for a negligent misstatement. You know, they would say that the content was misleading. So we've got to make sure that what we write doesn't lead a reasonable person to make an incorrect inference, whether as a result of the information itself or the lack of information or the manner in which it's recorded. Okay. What you find often in, you know, in large employers in particular is this, what I would call a gravestone or a tombstone styled reference. So when the employee started, what they did, when they left, and often reason for leaving is given as well. I was one case that sticks in my mind, it's years old, Dyke and Rickman. And this was, Mr. Dyke was an independent financial advisor, and he was offered a job subject to satisfactory references, which is completely normal and fine. And his previous employer provided a reference which was pretty awful. It said things like, he's a really difficult person to work with. We definitely won't be sorry to lose his services. You know, this was not a sad decision for us, you know, these kind of things. And they went on to say that we'd received 2 complaints of sexual harassment from him. I think it was a secretary and an office cleaner, and he was cautioned for the complaints, but of which he denied or whatever, something like that. Anyway, his new employer, his prospective employer, strangely enough, decided to withdraw the job offer. So Mr. Dyke had nothing left to do bar sue his previous employer for breach of contract and negligence in giving this unfavourable reference. However, the company defended their position by saying that this reference is true and it was not negligently given, it was purposeful. And amazingly, all his claims were dismissed because they were able to prove everything they'd said. There were 2 complaints about sexual harassment, but they had included in the reference that he denied them and was only cautioned about it. You know, there was good reason for them to say they were pleased to see him go. I think he'd failed all his targets, he'd missed lots of deadlines, there was lots of correspondence about it. You know, I would never promote the writing of a reference in those kind of words, but thankfully they were able to prove that they were true. And to add insult to injury for Mr. Dyke, he was then told he had to pay their costs, and I think it was about £70,000. So bad news all round in that case. But, you know, obviously if we're going to give negative or bad references, we need to make sure that we've got the evidence that backs them, and it's appropriate to do so. Number 6. So this is the myth that, again, it's a really common one. When an employee is dismissed for gross misconduct, you don't make any further payments. So that's often presented as like any further payments. It's absolutely true. If you dismiss someone for gross misconduct, you don't pay their notice. They don't work their notice and you don't pay their notice. But they're still entitled to pay in lieu of accrued holiday pay and any other payments that might be ordinarily due. The only thing they don't get paid is their notice. So they might still be due to get paid bonus, for example, unless there's discretion in there or the ability not to pay for someone on notice or who has dismissed. The other one I hear connected to that is the expression summary dismissal for gross misconduct can be taken literally, i.e. you find out what someone's done, you dismiss them there and then. And again, that's not true. We still have to go through the procedures that we have. So when a tribunal looks at the fairness of someone's dismissal, they look at 2 things. They look at, is it procedurally fair and is it substantively fair? So the substantive fairness is, was there good enough reason to dismiss for whatever that person did? So that's substantive fairness. And then the procedural fairness is, do the requirements of your policy and the ACAS code of practice, have they been respected and followed? You know, was this person given notice of what they'd done wrong in a letter, and time to prepare, to attend for a hearing where they were able to make representations, and someone considered those before they reached a decision, and they had an appeal? You know, all the normal things that you would do for a disciplinary process would have to apply. Okay, so it's not a matter of, oh, look what they've done, give them a call and let them know that they're finished. Okay, back to another poll question. So our last one, question 4, an employee whose fixed term contract comes to an end cannot bring a claim for unfair dismissal. So I noted down what our responses were, and it was that 78% said you cannot claim for unfair dismissal, and 22% said you can claim for unfair dismissal. Well, the answer here is that you can claim for unfair dismissal. So only 22% of you got that one right. An employee whose fixed term contract comes to an end can claim for unfair dismissal if they have more than 2 years service, and obviously they can show that there is a potentially unfair reason for their fixed term contract not being renewed. So the Employment Act says that the failure to renew a fixed term contract on the same terms is a dismissal. So it's really straightforward. The failure to renew a fixed term contract on the same terms is a dismissal. Now, whether it's a fair or unfair dismissal then depends on why we're not renewing it. So let's say we're not renewing this fixed term contract. Let's say in all our examples, the person has 2 years service. Let's say we're not renewing the fixed term contract because you've done the work. So we gave you a 2-year fixed term contract because there was 2 years worth of work to do and you've done it. So we're not renewing it because there's no work for you to do. Well, that in effect is a redundancy decision. If there's not enough work for someone to do, then that is in effect redundancy. And that once somebody's got 2 years service, they're entitled to redundancy pay. And there's a whole process when we make people redundant to follow. Again, individual consultations, search for alternative employment, all those kind of things would apply if someone had more than 2 years service when their fixed term contract came to an end. Let's say that this person actually wasn't that good and their fixed term contract will come to an end. Again, they've got the 2 years, and let's just go out and find someone better. There's better people out there. Well, that's a capability dismissal. That's a poor performance, you know, incapable of doing the job dismissal. So that person would be able to say, well, where was my warnings? Where was the time to improve? Where was the search for alternative employment, which you would have to do for a capability dismissal? So I hope you can see that if you are going to make someone leave because there's no more work for them to do, or you would rather get someone better to do the work, you still need to think about what's the fair process that should precede the failure to renew that fixed term contract. Okay, only applies to people with 2 or more years service. So that's a big differentiator. Excuse me. Number 8. This is the myth that everything should be prorated when you work part-time. And that includes the 10 keep in touch days for employees on maternity, adoption or additional or shared parental leave, and the 20 days in shared parental leave. So you get 10 keep in touch days when you're on maternity, for example, and 20 when you're taking shared parental leave. But if you work part-time, those should be prorated. And that's not true either. Obviously, lots of things are prorated when people work part-time, but the legislation on keep in touch days makes no provision for those to be prorated for part-time workers. Okay, they still get the full 10 or 20 allowance. And that, we finished a bit earlier, is the last myth that I was going to look at. So let me see if there's any more questions. No, I've just opened that and there aren't. So unless there are any more questions now, that's the end of our webinar, and I want to thank you all for your questions and for participating. If you've got anything that you would like to contact me on independently, then please have a look at my or contact me on my LinkedIn profile. That's absolutely fine. And yeah, I'll answer any additional questions if they come in. Thank you all very much.